Terminally ill people in Illinois may soon be able to end their lives with medical assistance. State lawmakers recently passed the controversial Medical Aid in Dying bill that now heads to the governor's desk. Supporters of the measure say it gives those who are already dying a compassionate way to go. But opponents say the measure would worsen longstanding healthcare disparities, particularly for individuals with disabilities and people who live below the poverty line. Joining us now with more on the bill are Kade Bennett, the Director of Advocacy and Intergovernmental Affairs at the American Civil Liberties Union of Illinois, and Amber Smock, Vice President of Advocacy at Access Living. Thanks to you both for joining us. So, Kade, starting with you, this bill has passed both houses in the General Assembly. Governor Pritzker says that he is considering it. He's reviewing it before signing it into law or not signing it into law. Why do you think this law is needed?
It's needed because of people like Deb, who this bill is named after, people who are terminal, 6 months or less to live, who want to live, but they know that they're going to die. There are people who've tried every kind of clinical treatment trial, and they know that at some point they are going to die a pretty painful death. So this will bring Illinois in line with 11 other states in the District of Columbia to add another end-of-life option for people who are terminal.
And briefly, you named Deb, for whom this law is named.
Yeah.
Who is Deb?
So Deb Robertson, she is an advocate who's been working on this bill in the last year and a half, 2 years. She's somebody who was diagnosed with a pretty rare form of cancer, and it's been her mission to make sure that this bill becomes a law in Illinois. And, you know, as of right now, we don't know if Deb will make it to when this bill is signed. It's a 9-month before it goes into effect, but it's so important for her because one of the things she worries about, and in the networks that she's a part of with other people of this kind of cancer, is the knowledge that at the end it is very, very painful. There's no kind of medical breakthrough. Pain is something that is real, and this would give her a peace of mind knowing that this can be an option.
Amber, your group, though, you all have said that this bill would hurt those with disabilities, people who are lacking health care access. How so?
So right now, something like 82% of physicians actually have reported that they regard people with significant disabilities as having lower quality of life. And a good deal of this bill's discussion is about whether or not people are having quality of life. Now, the bill is technically designed to serve people who have 6 months or less to live. But the problem with that is that you're predicating a bill on something that is actually not reliable. Medical diagnosis of having 6 months or less to live is actually not that good of a predictor as to what will actually happen to people. Plenty of people live past the diagnosis, plenty of people live, you know, with a little less time than that. But what we are trying to get across for people with disabilities is that, I'm so sorry.
It's okay.
Yeah. What we're trying to get across for people with disabilities is that you just really don't know the day-to-day existence of disabled lives and what we deal with when we go to the doctor. So when I say that you go to the doctor, you can't know for sure if your doctor is going to give you the best possible recommendation because maybe your doctor actually has a disability problem. How can you count on that being really healthcare? And right now, this bill is offering suicide as a healthcare measure, and I don't think anyone will call that healthcare.
Can I just say, I think for people like Deb who've talked about what this option would mean for them, they're very clear that this is not suicide. These are people who want to live and they know that they're going to die. They're part of her doing every single clinical trial is because she really wants to live, but she knows that the end is going to happen and she wants to have control. And we see this as a type of bodily autonomy. People who are facing a terminal illness should have the right to make the best decision for them. And for some people, that may mean using medical aid in dying. And for some people, just the idea that they have access to this medication could be all that they need for them to feel comfortable at the end.
And for people with disabilities, that kind of choice doesn't actually exist. So a lot of people do want to be certain about the end of their life. They want to know what's going to happen with them. But for a lot of people with disabilities, the choice on how to live their lives is actually a day-by-day process. And right now, there are a lot of people who don't actually experience real choice because there is so much of their lives that is outside of their control. They may not have access to housing. They might not have access to home and community-based services. They may not have access to pain mitigation. Those are the things that we should be looking at, not offering yet another way to die.
Kadeen, some lawmakers have raised concern about there not being enough safeguards and not enough guardrails in place to ensure that that people aren't being basically coerced into life-ending treatment. What are those guardrails?
So a lot of the law is patient-directed. So if you're a terminal person, you have the capacity to give informed consent, you're an adult, so over 18, and you have a prognosis of 6 months or less to live, then you can start the process. So that means that you would have to speak to an attending doctor, confirm your terminal diagnosis. There has to be a consulting doctor to confirm your terminal diagnosis to make sure that you are not simply depressed, that that you would give an oral request, a written request, another oral request. There's a 5-day waiting period before the first oral request and the second oral request. There are guardrails in the language that makes it clear that somebody, that you can't be coerced. If anyone were to coerce you, they can they could be civilly or criminally prosecuted for that. There's language that says that an insurance company can't condition care on somebody using medical aid in dying. So if this became law, then your insurance company can't say, we're not going to do those other end-of-life options, where they have to continue to provide the care that they already provide there. There's language that says that for the written request, there has to be a statement and witnesses. One of those witnesses can't be somebody who in any way benefits from the law. So we have a lot of protections in place.
So, Amber, what are your thoughts on some of those guardrails? Are they not enough?
Yeah, so I think Kade is listing a lot of guardrails, but every single one of those guardrails have workarounds. They do. And I want to point out specifically the insurance industry. We know that the insurance industry's bottom line is money, it's not human interest. And that is a really big problem when you have instances like such as what happened in California. There was a case where a woman needed coverage for chemo, but the insurance company wouldn't cover it. They said instead, you know, we'll cover lethal medication if you want to kill yourself. So you cannot control insurance companies to the extent that you might like to. In addition, I would also say that this is, if the governor signs this, and I certainly hope he doesn't because it's going to create a problem. If the governor signs this, what is going to happen is it's now a law. And you know what, the thing about laws is you can come back with amendments. And there certainly are people who are significant proponents of going even further than what this law does. They want to shorten the time that it takes to get there. They want to make sure that people from out of state can access it. And ultimately, we're going to see what happened in Canada, where people come back and say, let's open it up to more groups of people that want to kill themselves.
So to that point, though, I think the first law in Oregon was passed in 1994. It went into effect in 1997. And there are, as I said before, 11 states and DC that have the law in the books. This slippery slope argument hasn't played out in the US, and that's what we're talking about, a law that hopefully will become a law in the US. What's happening in Canada has nothing to do with this conversation about terminally ill people who want to be able to choose for themselves an end-of-life option that is has been proven to be medically okay. We've not seen some of these concerns that's been raised in other states.
Couple seconds left, Amber. Go ahead. I'll let you have the last word. 15 seconds.
What happened in Canada has everything to do with what's happening here. People are humans. The movement for assisted death is a global movement. And so we are very concerned that what happened in Canada, what people should understand, is that Canada opened up assisted suicide to people with disabilities. It is as simple as going online, filling out a form like at the DMV, and now 5% of all deaths in Canada nationwide are through lethal medication.
All right, that's where we'll have to leave it.